You are listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to LawWithDenise.net. My name is Denise. In this episode, we're asking the following two questions. We're asking, does the postal rule apply to acceptance made by email or telex? And if acceptance is made by email or telex, but it is made outside of normal working hours, how does the court determine when and where the contract was formed? In order to answer those two questions, we're looking at the following three cases. We're looking at Entores Limited and Miles Far East Corporation, Brinkibon, and we're also looking at Thomas and BPE Solicitors. Now, question number one, does the postal rule apply if acceptance is made by telex or email? In our first case, Entores Limited and Miles Far East Corporation, the acceptance in question was made by telex, and the court told us, no, the postal rule does not apply. The court said telex is a form of instantaneous communication. Therefore, if we use instantaneous communication, the communication is almost identical to that communication the parties would have had if they had contracted face-to-face. And therefore, the courts decided the rule to apply was not the postal rule, but was in fact the normal rule of acceptance and communication. And that is that acceptance is made once the recipient receives the acceptance. So the parties in question included a claimant in London, a London-based company, and the defendants in Amsterdam. The claimants sent out their offer from London to the defendants in Amsterdam. And the defendants sent their acceptance from Amsterdam to London. Following the court's decision that the postal rule was not to be applied, the courts decided that the contract was in fact formed in London, because that's where acceptance was made. In Brinkibon, we also had similar facts, involving a company in London and one in Vienna. And again, it was telex that was the issue. And the court followed the rule in Entores Limited and Miles Far East Corporation. And they decided in that case that the contract was formed in Vienna because that is where the acceptance was sent to. So, to conclude, if it is telex that is of concern, then what the courts have told us is that definitely telex is a form of instantaneous communication, and therefore the postal rule is not applied. And our cases of reference are Entores Limited and Miles Far East Corporation, and then Brinkibon, in which Entores Limited and Miles Far East Corporation was applied or followed. Now, in terms of email, things are not so clear. Our case of reference is Thomas and BPE Solicitors. And it is not so clear because the statement I'm going to tell you about was made obiter. So it was said that if an acceptance is made by email, it would not follow the rules of the postal rule would not be followed. But this statement was made obiter. So for telex, we're absolutely clear. No, the postal rule does not apply. But for email, we are relying on an obiter statement made in the High Court, and that statement was made in Thomas and BPE. But the statement did tell us that the postal rule would not apply to emails. Now let's move on to our second question. Our second question is, what if this acceptance is made outside of working hours? How does the court then determine when and where the contract was formed? Now, in Brinkibon, and in Entores Limited and Miles Faris Corporation, this was not an issue because the acceptances in question were made within working hours. But in Brinkibon, the House of Lords did tell us that if we had such a situation, this is how it would be dealt with. The House of Lords concluded that if acceptance was made outside of working hours, what would need to happen is that we would need to look at the intentions of the parties, the standard business practices relevant, and we'd also have to look at where the risk would more fairly lie. So with which party would the risk most fairly lie? And in Thomas and BPE in 2010, the High Court had to and needed to follow these steps laid out by Brinkibon, because there was a question of whether or not the recipient of a particular email had received that email within or outside of working hours. You see, the one party sent an email at 6 p.m. on a Friday, but when that email was sent and hit the inbox of that party, that person to whom the email was sent had left the office 15 minutes before. So that person had left the office at 5:45, but the email was sent and received at 6 p.m. And there was a question of when acceptance had been made and whether or not the acceptance which reached the inbox at 6 p.m. was in fact effective. Now, the courts looked at the whole context of the situation, and it was concluded that acceptance, that email that hit the inbox at 6 p.m. was in fact effective. So to sum up the answer to the second question, what you need to bear in mind is that if the acceptance is made outside of working hours, what the courts will do is the courts will look at the following. They're going to look at the intentions of the parties, the standard business practices relevant, and they're also going to look at where the risk would most fairly lie. So they're going to look at the case in front of them, and they're going to look at its whole context. And you can then mention that this was done in Thomas and BPE. The courts had to decide this, and they looked at the case in its whole context. So I hope that was helpful. 3 significant cases for us in contract.
You've been listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.